Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to everyone. My name is Muhammad Farid Hazik bin Muhammad Shaharin, and today I will be presenting briefly on a case review on a case of Sealdeck, Sdn Bhd, and on Choon, which falls under the topic of illegality. So let's look at the facts of the case. So the facts of the case sounds like this. So the defendant is the registered owner of a land. He later entered into a tenancy agreement with the plaintiff, which was signed on 23rd March 1996. Could they reach an agreement as to the amount of rent which required to be paid monthly, which is 4,500 ringgit. But however, the plaintiff decided on his own volition that he wanted to pay in advance as to the first month. There was an express condition which actually prohibited the use of the place for any business purposes, which means that business are not allowed to be conducted, and what are allowed is for the plaintiff to reside. So ironically, the plaintiff had done the opposite. He has used the place for business purposes. He constructed a single-story building on the land to accommodate trade stocks. Later, plaintiff was prevented from continuing with his business. Subsequently, he decided to repudiate or terminate the contract, and then the plaintiff filed a lawsuit for misrepresentation and breach of tenancy agreement. The plaintiff contended that the defendant has failed to disclose that the land was actually sold to a third party, and that the third party has successfully obtained a restraining order from the court, which prevented the plaintiff from furthering erecting the store. Now let's look at the legal issues. The legal issues that requires the court to answer. First is whether the defendant misrepresented to the plaintiff that there was no restriction on the usage imposed on the land. Second is whether the object of the agreement was unlawful. Third is whether the plaintiff has the means to discover the truth by applying ordinary diligence. And lastly is whether the tenancy agreement was void and unenforceable by either party. Now we look at the plaintiff and the defendant counsel argument. The plaintiff counsel argued that the defendant has applied false misrepresentation, and as a result, it has induced the plaintiff into entering into the tenancy agreement. The defendant stated that there was no condition imposed that restricted the plaintiff from using the place to conduct his business. And the defendant has also failed to disclose to the plaintiff that the land was actually sold to a third party. But in contrast, the defendant argued that the breach was on the plaintiff, as the plaintiff himself has failed to obtain or to procure the permission of the state authority prior to erecting the building. The defendant also argued that the plaintiff has failed to pay his monthly rental, which amounts to 4,500 ringgit a month, which started from 1 to March 1996 until 31 December 1998. Hence, the defendant is seeking for the return of the payment. Now let's look at the judgment of the case. So the court held that there was a clear condition, there was an express condition that prohibited the plaintiff from erecting the building or from conducting the business in such place, and it was only merely permitted to reside. Hence, the purpose is forbidden by the law under Section 1 to 7 of the National Land Code. The court referred to Section 66 of the Contracts Act, which requires the defendant to return the deposit paid by the plaintiff, which amounted to 9,000 ringgit. And the plaintiff has also failed to perform his duty or his responsibility, which is to apply ordinary diligence to find the truth, or apply ordinary diligence to be conversant with the law. As a result of not being conversant with the law, he has done something that is contradictory to the law. He should have been aware of the law by conducting land office research. So this is clearly a failure of the plaintiff and a reckless act on his part. The plaintiff's contention that he was falsely misrepresented is groundless because the plaintiff has all the means to discover the truth by himself. And Section 19 of the Contracts Act covers on the exception of the voidability of the agreement, which is that a person has the means to discover the truth by applying ordinary diligence. the court hence dismissed the plaintiff claim and also the defendant counterclaim, and only allowed the defendant to actually refund the deposit paid by the plaintiff. Lastly, we look at the commentary or my opinion on the judge's opinion. So the plaintiff, having the intention of erecting the building, should have sought assistance and advice from a lawyer prior to erecting the story building or before conducting a business. The plaintiff should have actually seek an assistance from a lawyer. So by seeking an assistance from a lawyer, the lawyer would expose the plaintiff to the do's and to the don'ts, what is forbidden by the law and what is not forbidden by the law. When the plaintiff failed to seek an advice from a lawyer, he will not have been conversant with the law. He does not know what is the truth and what is not. So I disagree with the judgment of the court that the plaintiff should have actually applied ordinary diligence. It is a clear concept that ordinary diligence can be exercised in many forms and in many ways. So the plaintiff has actually exercised his duty by asking pertinent questions in regards to the condition imposed. So the court cannot expect the plaintiff to do more than what he has actually done. By asking pertinent questions, it should be suffice and enough to prove to the court that he has applied ordinary diligence. By asking pertinent questions, it proves that he endeavor or he is putting effort to find or to procure more information on the tenancy agreement and to be aware of what is forbidden and what is not. So the plaintiff did perform his part by asking the landlord on the condition imposed. However, the landlord himself stated that there is no condition imposed and he is free to erect the building. Okay, this is clear that the plaintiff has actually exercised sufficient ordinary diligence, even though he was not aware with the express condition that prohibited him from erecting the story building prior to procuring the permission of the state authority. But if we apply section 17A, there was a fraud committed by the landlord because the landlord has clearly deceived and induced him to enter into the agreement. The landlord has failed to disclose the truth. The time the plaintiff asked the question regarding to the express condition, there existed a duty on the part of the landlord to tell the truth and to expose to the plaintiff that it is contradict to the law and that he is required to seek permission from the state authority. The plaintiff and any reasonable person would perceive the landlord as having the exclusive knowledge. He should have known that there is an express condition. And when he knows that there is express condition and that the plaintiff has exercised ordinary diligence, then he is required and incumbent to tell the truth. But if we look in other circumstances, if the plaintiff did not ask the question, then there is no duty of the landlord to actually tell that he is required to seek permission from the state authority. But when he asks, then he has the duty to tell the truth. So since we assume that the landlord should have actually know and should have actually have the exclusive knowledge, he literally and expressly deceived the plaintiff to enter into the tenancy agreement. So this clearly shows that the defendant is ignorant and that he failed to exercise his duty by speaking the truth. And lastly is that by referring to section 66 of the Contracts Act 1950, the court has perfectly applied, which section 66 covers that any parties that receive advantage from a void agreement, they must actually return the advantage back. So in this case, the deposit must be returned. So that's all from me. Thank you.